in putting on these webinars. So thank you so much. If you have any questions about what the amazing Cedric team do feel free to reach out to the SPSP team or Cedric directly, and we're happy to answer any questions you have. Please do use the Q&A function. This session is for you, so ask any questions that you have, and we will try our best to address any questions that you may have. So this is the fourth webinar that we've been doing this year, and you'll see here on this slide we've got a few more coming up, so make sure you add these to your diary. We've got one on process control, so really important in terms of manufacturing, and then also safety of components and raw materials there in June. So we hope to see you back for those webinars. So at this point I would like to hand you over to Ed.
Thank you so much, Geraldine, and what a pleasure to be back giving one of these sessions. My name is Ed Turtle. I'm part of Cooley's global products team. For those of you who don't know Cooley, Cooley was founded in Silicon Valley around 100 years ago, and we've become particularly known as a leader in tech and life sciences, and increasingly I like to think in the product space as well. I spent the last sort of decade and a half advising clients in a whole range of different sectors on product compliance, product safety, and liability issues. And alongside that, I also do a lot of policy work, helping clients understand what's coming down the line and how those developments are going to affect their business. I'm a dual qualified lawyer with EU and UK qualifications, but my practice is very global. I focus particularly on product launch, and over the last couple of years, I've helped clients launch products in around 140 countries. So it's a truly global practice at Cooley. I focus on areas where technologies are new and the law hasn't adapted yet, and it's a really compelling area of the sort of product space, and a real privilege to bring sort of innovative products to market. So with that, I'm going to hand over to Fergal so he can introduce himself as well.
Thanks, Ed, and hi all. It's great to be here with you. My name is Fergal. I'll keep my intro very brief because we have a lot to get through, but I've been a lawyer at Cooley for about 9 years, and I support Ed with the whole manner of things to do with innovative, novel products. And I'll pass it to Carol.
Thank you both. Yes, I'm Carol Holly and I'm an associate in the products team in London. Also, I too have been with the team for almost 10 years after we set up here in London, and I'm really looking forward to speaking to you all today. And I think I'm passing back over to you, Ed, to give a quick intro into what we're going into before we launch into the substantive deck.
Thanks so much, Fergal and Carol. I'm going to keep this fairly brief because I want to get us started on the sort of meat of what we're going to cover today. But we're going to be covering three main topics today, and those topics address different parts of the product lifecycle. Cooley has the largest sort of dedicated products team of any firm, and we cover all parts of that product lifecycle. That includes the sort of product development and launch phases. We like to get involved as early as possible. Not always the case, but the sort of earlier we get brought in, the better, really. We then provide sort of launch advice to lots of companies, helping them navigate in a whole range of different markets. Then we handle lots of sort of in-market issues like regulatory investigations, recalls. We always have a few recalls going on in the team at any time. And then also claims and product liability issues, which we'll be touching on today. Finally, the last sort of piece of that whole life cycle is the end of life piece. Work closely with our ESG colleagues on that, and it's an area that's becoming increasingly regulated. So we see a lot of issues cropping up there. We're pretty unique in having that full spectrum coverage, and it's nice today that we've sort of been able to choose three topics that reflect that life cycle. So if we turn to the next slide, the three topics we're going to be covering today are focused on product compliance and safety updates. Carol's going to sort of bring us up to speed with those. Very relevant to the sort of product development, conformity assessment and pre-launch stages. Then Fergal's going to provide a bit of an update on consumer laws and sustainability developments. Those are particularly focused on the sort of point of sale requirements. There's a lot changing in that space in Europe at the moment. So So buckle in, there's quite a lot to cover. And then after that, I'm going to look at some new litigation risks, including an update on the EU's new product liability directive, the revised version that will be going live in December. So we're really in the sort of final phase before that comes into effect, and very much want to sort of bring you up to speed with what's happening there. We're going to try and leave a bit of time for questions at the end, but please feel free to pop those in the Q&A. And if we don't have time to get to them, or if you have very lengthy or specific questions, please feel free to reach out afterwards. We're always happy to address those, and the deck will be shared and has our contact details. So we'd love to hear from you. Right, with that, I'm going to hand over to Carol, who's going to get us started with the product compliance and safety updates.
Thank you, Ed. So I'm going to kick off talking a bit about the European General Product Safety Regulation, and importantly, the direction of travel, since this was last touched on in a Cooley SPSP presentation. I hope you'll forgive me, because I've been reassured by the fact that you will all be very up to speed with the basics of some of this, but I hope you'll humour me just touching on a couple of key examples from this slide of things that I find most interesting in the context of what they tell us about where things will continue to move, both in the UK and in the EU. So the first one here, aligning the requirements for harmonised and non-harmonised products. This really, for me, a key point here is the expansion of the responsible person requirement. This was introduced under the market surveillance regulation in the EU a couple of years before the GPSR was brought into force, and initially was just for products covered by the CE marking legislation. But the GPSR expands that much more broadly so that it covers all consumer products within the scope of the GPSR. And this was a really significant change, not long after it was first introduced for a much more limited scope of products. And I think it's a really interesting example of the sorts of measures that the EU is taking in order to try and address concerns about unsafe and non-compliant products that are entering the EU from third countries. On new technologies, and I'm going to talk a lot more about this in the next few slides, a headline point here to be aware of from the off, though, is that the definition of product is now wide enough to cover non-tangible items such as apps and software products. And in addition to that, risks for mental health and also cybersecurity risks that might affect the safety of the product are now brought into scope. Another really significant area of change is in relation to online sales, and specifically obligations for online marketplaces. So in the EU, online marketplaces now for the first time have a minimum set of obligations. But it's worth noting that the quite long-awaited European Commission guidelines that came out towards the end of last year actually go a lot further in trying to recommend that those marketplaces go further than that minimum set of mandatory legal obligations and do some extra things voluntarily as a matter of best practice. Another interesting area is that accident reporting is now established in the EU. So manufacturers are now obliged to notify accidents that meet a defined seriousness threshold, which is death or serious adverse health effects, even if those are temporary. And if the manufacturer is not based in the EU, then the responsible person for that product must ensure that notification is made. Again, in relation to online marketplaces, what's interesting is that not only do they have an accident reporting obligation, but their threshold appears to be a little bit lower because it refers to a serious risk of injury rather than actual adverse consequences for an individual having occurred. And in addition, they have an obligation to inform a manufacturer of a product. So there's a lot going on there in terms of this new accident reporting requirement. From a practical perspective, early on there were quite significant challenges for companies in reporting accidents because the safety gate system used for reporting wasn't really designed for this purpose because it was set up for reporting products presenting a risk, corrective actions, and safety risks. So, for example, initially it was mandatory to include a risk level following a risk assessment as part of that report and to indicate actions that were being taken to address that safety risk. So it wasn't really geared for reporting individual accidents or incidents that had occurred. But the good news is that following feedback from various stakeholders, the European Commission has updated the reporting form to address these issues. So you're able to now include unknown where appropriate. So it works a little bit better, although I think not perfectly, some might say, for these purposes. And on the enforcement point, I wanted to flag that the European Commission has announced that it is considering establishing an EU-wide market surveillance authority, so a centralised enforcement body, as part of the upcoming European Product Act and revision of the new legislative framework. Again, this is looking partly at targeting the sale of unsafe products online. So it's still a little bit of a way off, but it is an interesting sign of the direction of travel. And before I move on from this slide, I also want to flag a really important update in the UK from the last couple of weeks, which is that the UK has just launched a really major consultation on reforming the product safety framework here. That's going to close on the 23rd of June. So if you are interested and affected, we really recommend that everyone take a look at that, because there are some really significant proposals within it that are worth submitting views on if they are relevant to you and might impact you. So just again to highlight a couple of key things. In terms of EU alignment, the headline point is that the UK wants to be able to complement EU rules and support trade, but there are still potential divergences there. So the UK is proposing a broader product scope than the EU, so that would cover non-consumer workplace products, for example. And on the point of standalone software, which I mentioned, the EU is treating that as a product in its own right, but the UK is not proposing to do so, which is again quite an interesting split in how things might be approached going forward. Online marketplaces, also a really key theme. So for the first time then in the UK, the platforms would be facing explicit duties, including a due care duty to prevent and remove dangerous products, as well as a due diligence duty to act against repeat bad actors. Another specific proposal that would be mandatory in legislation relates to verifying seller contact details. So again, some really interesting shifts there in the UK that look similar to what we've already seen in the EU. There's big discussion on what enforcement in the UK will look like going forward, including potentially a move away from criminal prosecution, which has been a really key part of the enforcement landscape here for some time, towards more civil monetary penalties. And on new technologies, there's proposals for safety assessments that would expressly cover cybersecurity and AI risks, again, broadly mirroring the EU, so not a huge surprise, but interesting to at least see how the UK might approach that and whether that might differ. And again, on the online product point, online sale of products, those listings might need to disclose whether or not a product uses AI, which actually will be going a bit further than the EU position. If we could move then to the next slide. So just having given you that brief refresh on the EU GPSR, we also wanted to take you through some updates from the European Commission that we've heard at recent policy forums. So as I mentioned, the GPSR includes these new requirements around mental health risks and software. And this is including hardware, embedded software, and also standalone software. And the European Commission has been working with member state authorities to build capacities for market surveillance in these new areas. You know, this is new to all of us, it's new to regulators as well. And there have already been specific discussions within the market surveillance network about mental health risks and future testing, with specific discussions around the testing of virtual reality products. You'll see reference at the bottom of this slide to two studies that specifically focus on mental health, among other things. One of those is the e-vulnerability study that the European Commission is undertaking, which is looking at consumer vulnerabilities in online environments and their impact on product safety. And the other is the study into new technology products, which is funded by the European Commission, but the OECD is undertaking. So these studies are not yet final, but the OECD presented some preliminary findings from its study earlier this year, which included some quite interesting points. One of those is that no market surveillance authority has been able to cite a report of mental health harms associated with a digital technology product, but it has noted that the true scale of physical and mental harms does remain uncertain. So for example, consumers might not recognize these as incidents, and it might mean that those issues are being They also reported that AI incidents involving products and physical harm appear modest and stable since 2022. Another interesting area of development is around this inclusive risk assessment. So the GPSR's requirements, which are new, expressly require consideration of the impact of gender differences among, as well as factors such as age, as part of the assessment of safety. And that has to be taken into account as part of a pre-market risk assessment. And so the European Commission has been coordinating with member state authorities on implementing this requirement for inclusive risk assessments. I think, unsurprisingly, the Commission has acknowledged that this is quite challenging in practice, not least due to a lack of data, standards which are based on averages rather than ranges, and the potential that, in fact, measurements that are relevant for certain consumers have been excluded. So a really obvious example that I'm sure many of you will have already heard reference to is crash test dummies being based on a male body and not a female body. And so the Commission has been looking at whether there have been an evolution of measurements for certain consumers that might be more appropriately taken into account. And again, just before we move on, just to flag these 3 studies on their own, because I think they do merit these specific call-outs. These are all expected to lead to further policy discussions, and so we would expect that those in time will feed into guidance for policymakers and also regulators. So the e-vulnerability one, which I mentioned, that's a study exploring how new technology products affect consumer vulnerability, identifying the most significant safety risks, including mental health, as I mentioned, and also effectively communicating safety information in digital environments. That is expected to be published in the summer of this year. The second one mentioned here, the impact of circularity on safety, is looking at things like second-hand, repaired and refurbished products. And the Commission has said here that digital product passports could serve as a solution to some of the issues that are being raised. So, for example, faded labels or the absence of original documentation. And again, we are expecting to see that published quite soon. And lastly, the new technology products, which is the European Commission OECD study, that is looking at risks including mental health harms that are associated with AI, the Internet of Things, and AR, VR. And again, we are expecting to see that published soon. If we could move on to the next slide, please, Fergal. And before I hand over to you, I will just briefly canter through some of the changes made to the EU risk assessment methodology, because these are quite interesting, and then we can move on to some more of the updates from the rest of the team. So this is a new risk assessment methodology that has come in as part of the new GPSR, and it essentially combines risk assessment guidelines from 2 of the previous one was an implementing decision of the Commission, and the other was the previous EU General Risk Assessment Methodology for Harmonized products. There's a few changes that this new methodology brings into place. One concern for companies that we have been helping them navigate is that the new methodology expands the list of cases that would be deemed to present a serious risk without a national authority needing to conduct a risk assessment. So under the former risk assessment methodology, there were already examples of this, and largely those covered chemicals and certain risks that were associated with children's products. But the new list is much broader, and it includes things like scenarios where there's well-documented evidence that certain features of a product can consistently lead to a serious risk. Adding in, for example, electrical products with defective components that might lead to electric shock or fire risk, or also where the product has been subject to a recall, withdrawal, or removal of online content based on voluntary measures, either by economic operators or providers of online marketplaces. So that broadening is quite an interesting example of where this new methodology might result in changes. Now, the European Commission clarified in a Q&A document that this presumption, so the presumption of the need for a risk assessment, is a rebuttable one. And so that does mean that there is scope for national authorities to consider information that is provided by a manufacturer or an importer that in fact that product does present a less than serious risk. But I would say, based on recent examples of engaging with European markets surveillance authorities, where they consider a product to pose a serious risk, that they are not always open to a discussion. So although that is a rebuttable presumption, it can be quite hard to move a regulator away from that conclusion if they have already reached it. So it is worth being aware of. And perhaps this is very unlawyerly of me, but I hope you will forgive me closing just with a couple of statistics that I found really interesting. And I don't usually like to go near numbers, which Ed and Fergal would attest to. But I was really struck in the 2025 report that the European Commission published on SafetyGate, which is that in last year, 2025, just over 4,600 alerts were notified into the SafetyGate system, which was the highest recorded number since the system was launched in 2003 and was a 13% increase compared to the prior year, and more than double the number of alerts that were reported in 2022, which to me feels like such a vast increase that seems quite clearly tied to these new requirements coming into place. And so what do I take away from that? Well, I think actually this is an example of legislative change having quite a quick impact on what we see in the market in terms of reported issues into the SafetyGate system, which I think we should all take note of. And with that, Fergal, I will pass on to you.
Thanks, Carol. And yeah, interesting stats. So I appreciate you sharing those. I wasn't aware of those previously. I was going to skip on to the next slide here. So I'm going to be covering consumer law and sustainability updates. And in about 15 minutes or so, I'm going to try and canter through 4 significant pieces of EU legislation. So these are the ESPR, which is on slide right now, the Empowering Consumers for the Green Transition Directive, the Right to Repair Directive, and the Batteries Regulation. Now, that's an awful lot of material, and frankly, they could all be spoken about for a couple of hours each. It wouldn't be a particularly interesting conversation, but a conversation nonetheless. So I wanted to start with 2 points. One is a helicopter view, and the second is to explain that at the end of each slide, I'm going to kind of give a brief explanation as to what I think you should be kind of thinking of top of mind right now. So what if I was in a company, what would I be worried about with this piece of legislation at the current time? So let's start with the helicopter view. Across all of those pieces of legislation, I think the key point is that the preparation window which you may need is actually shorter than the headline application dates suggest. So if your business or your products are in scope, all 4 pieces of legislation are likely to involve some form of operational change. Now, they can vary in kind of scope of that requirement or the actual the necessity of that requirement, but it could be changes to product design, to your supply chain, to your marketing, to your consumer communications. And these changes do require some lead time. So even though these look like some of them are, well, they previously were quite far away, now they're quite close. I really encourage you to start thinking about these requirements now if you haven't already done so. So with that being said, let's start with the ESPR. Now, the broad brush overview is the ESPR became law in 2024, and kind of the first and most important thing to note is that it's just dramatically expanded the scope of eco-design requirements in the EU. So the predecessor, the eco-design directive, it was just limited to energy-related products, whereas the ESPR scope doesn't limit it to that. It effectively applies to all products on the European market with very few exemptions. So if you are placing products on the market in the EU, the ESPR will almost certainly be of relevance. The key thing is the way in which it will apply to you may vary from company to company. And the critical thing here is that the ESPR is effectively a framework piece of legislation. It contains relatively few obligations in and of itself, but it establishes a framework for setting eco-design requirements via delegated legislation, and then your products will have to comply with that delegated legislation. Now, the delegated legislation will kind of include 2 types or categories of requirement. The first is performance requirements. So these can be requirements related to a product's reusability or repairability or the presence of substances of concern. And the second is information requirements, and that could include requirements related to kind of, for example, the use of repairability scores. It could also include requirements related to the use of digital product passports, which I know you've been spoken to about SPSP previously, but that's a digital record containing sustainability and supply chain information. Now, The ESPR is law, but the delegated legislation is not yet, and that will be phased across the next couple of years. The way the Commission intends to do that is to prioritize kind of high impact product groups for immediate sustainability requirements. And happily, it's settled on a few. So if you are in the supply chain for steel and aluminium, or textiles with a particular focus on apparel, furniture, tires, and mattresses, this is of particular relevance to you, but not just you, because there will be requirements coming down the line over the coming years as well. The delegated legislation for those product groups that I just mentioned is not yet available, but we'd expect it to be available soon because it's expected to be adopted in 2027. Now, alongside those specific kind of product group requirements, the Commission intends to also introduce delegated acts laying down horizontal requirements. This would apply across product groups, and they have focused on two requirements. The first is on repairability, and the second is on recyclability and recycled content. Again, the kind of scope of these measures and the actual requirements is currently being refined. There's a kind of a whole series of scoping studies and working groups working on this at a Commission level. But they're well worth keeping on your radar. And the kind of focus here would be manufacturers of consumer electronics and small household appliances, because those are the most likely products to be in scope. Again, if we think about where we prioritize our time, and look at the slide in that kind of third kind of square box down, the repairability of horizontal measure should be your priority, as that is planned for adoption in 2027, and the recyclability measure is a little bit later on. Now, finally, as I said, some requirements are actually set out in the ESPR itself. So despite it being a framework piece of legislation, there are requirements which apply as a result of the ESPR. And these are essentially requirements related to unsold consumer goods. So there are three which we need to take into account. The first is that the ESPR introduces a general principle requiring companies to take measures preventing the need to destroy unsold consumer products. So that kind of general principle applies now. The second is that companies are required to publish information on the quantities of unsold consumer products they discard each year, alongside their reasons for doing so. And there are various exemptions for SMEs, but this was broadly applicable now, with disclosures being required this year. And the third, which is potentially the most significant, is a ban on the destruction of unsold apparel, clothing, accessories, and footwear, again with various exemptions for SMEs. This applies from July 2026, but just so you're aware, there's a derogations process. I think it's just concluded, actually, confirming which products are exempt from these requirements, or which types of products are exempt from these requirements. And it's well worth reviewing that if you haven't already looked at it. So now, what headline actions would I be doing if I was someone in your shoes? If you haven't already done so, I think you should be considering two things, effectively. One is mapping your product portfolios against the working plan published by the Commission. And that would allow you to identify which product categories are appearing in this first wave of delegated legislation and what will be most relevant to you. And the second is confirming how you're going to address this unsold consumer products disclosure. Basically, do you have the right person lined up in-house to kind of own that obligation? And are you able to confirm whether you're in scope of the ban on destruction? Okay, ESPR done in 5 minutes or so. Check. We'll move on to the ECGTD, which is effectively impossible to say. Now, this works by amending two pieces of existing EU legislation, both with awful acronyms as well. The UCPD, the Unfair Commercial Practices Directive, and the second is the Consumer Rights Directive, the CRD. But effectively, we can ignore that, and it introduces kind of three substantive requirements. The first, as I've set out on the slide, is that it introduces new information requirements at the point of sale. Now, this could include providing information about spare parts, about repair restrictions, the conditions of after-sale service, etc. There's a whole host of stuff which is set out in the directive itself. The second is it introduces a new requirement for producers to provide consumers with certain information on their statutory rights via a notice or their commercial rights via a harmonized label. I actually have copies of this on the next slide, so I'm going to skip over that and I'll talk about that in the next slide. And I'll move on to the fact that the third thing that it does is that it bans generic environmental claims. So these are terms like environmentally friendly or green, and they're banned unless the business can demonstrate that you have recognized excellent environmental performance, which is an extremely high bar to meet. Now, the practical effect of that is that kind of the broad, unsubstantiated sustainability language, which we've become kind of somewhat familiar with and muted to, kind of prompted a lot of greenwashing claims. That will effectively be prohibited and deemed an unfair commercial practice. The directive also bans a whole host of other environmental claims and actions that could be considered environmentally unfriendly. They're set out in an annex to the directive. For example, I put 2 on the slide. And again, I'd encourage you to just take a look at the annex if you're particularly if you're involved in kind of marketing or advertising. If I just skip to the next slide, and then we'll kind of think of the things which should be top of mind. These are copies of the Harmonized notice on the left and the Harmonized label on the right, and they were designed by the Commission. So let's talk about the notice to start with, because it's more likely to be applicable to a broader range of products and companies. This notice must be displayed at point of sale, for example, as part of the checkout flow online or in store if you're targeting EU consumers and selling to EU consumers. And as you'll see, it contains details of the minimum 2-year legal guarantee protection for goods sold in the EU. And it also explains various things to consumers about their consumer rights, including that, if you're making a claim against the seller, they must be able to offer you a free repair or replacement, or price reduction or reimbursement. Now, that notice is not editable, so the kind of companies will have to display it in the exact form I've shown on that slide. If we turn to the label, on the other hand, this is the counterpart for commercial guarantees of durability. And really, it's a kind of narrower in scope we found when we're advising clients. It's only required if you are kind of meeting the following factors. If you're offering a voluntary commercial warranty at no extra cost for your good, with a duration of more than 2 years, and that last requirement is the thing that typically brings a lot of kind of warranties out of scope. But if you are doing that, you do have to kind of use this Harmonized label, and it must be displayed in a prominent manner, for example, by affixing it to the packaging of the product, or by placing it directly next to the picture of the good in the case of an online sale. So again, if I was in your shoes, what headline actions do I think should be top of mind for you? I think you should consider kind of conducting an audit of consumer-facing environmental claims to check if they're in scope of the prohibitions outlined in the ECGTD. You should be preparing for the Harmonized notice and labeling requirements where they're necessary, and assessing where these will need to be displayed, and kind of confirming whether you're in scope of the label requirements. And finally, I would be working with my online sales teams and supply chains to amend the information provided to consumers at point of sale. Okay, we'll move on to the Right to Repair Directive. Okay, so the Right to Repair Directive. Some of you may be familiar with this, but effectively it was introduced to shift the market practice from replacing devices to repairing them. And it does so in 2 main ways. Kind of firstly, inside the kind of statutory warranty, it incentivizes consumers in the EU to choose same device repair rather than replacement. So when making a claim against a retailer, it does certain things to kind of boost the chance of a consumer choosing to repair that device. Now, it does so effectively in 3 ways. The first, which I think is probably the most important, is that if a consumer makes that choice and decides to take a repair, their warranty period, their statutory warranty period, is extended by a minimum of 12 extra months. So you have to add that on to effectively what has lapsed to date. The second is that it requires retailers to tell consumers about this. So they have to know that they have the right to repair, and they have to know that if they choose a repair, the extended warranty period we just discussed will apply. And the third, which is slightly hidden, is that it actually adds repairability as a required product characteristic, such that if a retailer may be found to be in breach of a sales contract if the product is less repairable than consumers reasonably expect. And that's a new development in the Right to Repair Directive. So that all applies to kind of retailers and the kind of sales side. But the Right to Repair Directive also introduces a new standalone obligation to repair certain products, which will apply to the manufacturer, not the retailer. This is much more narrow in scope for now, but also is kind of very, very important to note. So it will only apply to those products which are already covered by repairability obligations in EU law, as set out in Annex 2 of the Right to Repair Directive. And these are effectively the obligations which previously applied in the Eco-Design Directive. So if you were in scope of the Eco-Design Directive previously, or the delegated legislation under the Eco-Design Directive previously, you'll be in scope of these requirements. it does apply. So, for example, if you're a manufacturer of white goods, so washing machines, dishwashers, fridges, or electronic displays, or mobile phones and tablets, you'll be in scope, but it doesn't apply more generally to consumer products. That being said, the big caveat is the Commission, of course, has the power to update this annex, and frankly, we expect they probably will do so to bring in more legislation in the future. There is an exemption to this repair requirement if you're a manufacturer. It's not required where a repair is impossible. That's the language. But even thinking about that word, it's already a very narrow exemption. Okay, the right to repair directive applies from the 31st of July 2026, so just over 2 months, about 10 weeks or so. So if I was again in your shoes, what would I be doing? What would I be doing right now? If you haven't done so already, I would be reviewing the scope of the kind of the products which I produce and determining kind of whether I would be in scope of the new manufacturer obligations under the right to repair directive. And if you are, I think you need to pretty promptly start considering how you will action repairs if you don't already, or whether you will try to seek to use that narrow exemption we discussed. And if I was a retailer, remember that you could be a manufacturer and a retailer, of course, I think I would be reviewing and redesigning my claims processes as necessary. So the obligation to actively inform consumers of their right to repair and the kind of 1 year extension, which that would allow if a consumer chooses it. That may require process changes, for example, by changing customer service scripts or educating your internal teams, which always kind of takes a little bit more time than anticipated. Okay, I'm going to move on to my final slide, which is on the batteries regulation. I know that many people on this presentation will likely be, the batteries regulation will likely be familiar to lots of people on this presentation, given the amount of debate it's definitely generated. However, I did want to recap some of the substantive obligations, especially as there have been some developments. So firstly, there are some new requirements related to expanded labeling and consumer information, alongside kind of compliance obligations. I've set those out on the slide. But the point I wanted to draw out here is that when we're talking about labeling, we mean labeling on the battery, kind of as an indication of what we're finding companies can get confused about is that, or are concerned about, is that if you're developing a consumer device, typically the battery is very, very small. The amount of labeling which now needs to be put on that battery is extremely large. And there is a challenge there where it's basically not possible. Ultimately, that information has to be moved somewhere else. So to the device, to the packaging, or accompanying documentation, depending on what depending on the specific labeling requirement, and that is causing a couple of hurdles for companies. Secondly, the big change under the batteries regulation, as you'll probably all be aware, is that it introduces a new removability and replaceability obligation. Now, this obligation only applies from February 2027. But it is posing a huge challenge for companies selling products incorporating batteries into the EU. Now, let's talk about the obligation very briefly in case it is new to you. This obligation requires products incorporating a battery to be removable and replaceable by an end user. That means that they have to be removable and replaceable without affecting the functionality of the device, using commercially available tools by the end user without the use of thermal energy or solvents. So effectively, they have to be kind of pretty easily removable. Now, limited exemptions are available and they've been much discussed, but they're very narrow, and some of them are only partial exemptions, i.e., you're still required to allow for battery replaceability, but it just needs to be done by an independent professional rather than a consumer. The key point I wanted to flag here is that and this is kind of hot off the press as such, following pushback from industry, the Commission is in the process of considering kind of limited extensions to these exemptions, and we've seen draft wording of that delegated act, and it includes kind of small wearable devices such as earbuds and smartwatches, and there's a consultation due to be published on this shortly. But again, note that even these exemptions or the new exemptions would only be partial, so you would still need to kind of ensure that your batteries are replaceable, but they can be replaceable by an independent professional only. The final point I wanted to draw on was the new supply chain due diligence requirements. And this kind of, as Ed said, we have this kind of confluence of ESG and product requirements, and this is an example of that. This is really the first time we're seeing the transfer of due diligence requirements from the ESG space into the world of consumer products. And this requirement will require businesses with a turnover of 40 million euro to map their battery supply chains, identify and assess risks of adverse impacts like human rights violations, establish due diligence policies and reporting procedures, and then have these audited by a third-party verification body. It's a huge, huge endeavor. And then you actually have to report publicly on the same. So for businesses that source batteries, which many do, from complex international supply chains, which many are, that's a really substantial undertaking. So I wanted to flag two things which could be helpful. Omnibus 4 proposes to increase the turnover threshold to 150 million euro for businesses in scope of that requirement. We understand that's under negotiation at the moment, so it shouldn't be relied on. And more importantly, as we have on the slide, these requirements were delayed until August 2027. Now, again, this is a useful delay, it's a useful extension, but it shouldn't be treated as an invitation to defer preparation. These types of due diligence programs take a long time to set up and do so properly, which I'm sure you'll want to do it once and do it well. So if you haven't considered it, you have been putting it off because of this extension, I would again start considering it now. Okay, my final headline points in case are the things that I think should be kind of top of mind for you currently. If I was kind of producing a product with like our portable batteries embedded, I would be conducting an immediate product review for the latest on the Article 11 removability and replaceability requirements. And I'd really keep a close eye on the exemptions to check whether I accidentally fell in scope if I wasn't sure. I would be kind of starting that due diligence process and the kind of mapping exercise that will require to build out a due diligence program if you are potentially in scope of that obligation. And finally, I'll be working with my battery supplier to review the labeling and conformity assessment readiness. Okay, that was my whistle-stop tour. I've seen some questions which I'm going to review now, but I'll pass over to Ed to make sure that we're not taking any more time.
Thank you so much, Fergal. So I was going to sort of close out with a bit of an update on some new litigation risks in Europe, particular focus on the EU's revised product liability directive, which we've been anticipating for some time and which is now going to start to apply in December this year. So we're really in those final stages before that starts to bite. This is the sort of biggest shake-up in EU product liability laws, certainly in my whole career, really in the last 4 generations, or the last 4 decades. 1985 was the previous regime, so we haven't seen any significant reform over that period, and this reform that we're about to get is much more significant than most practitioners were anticipating. Before I turn to look at those reforms in a bit more detail, I was just going to start with a little bit of background to the existing regime for those of you who are not too familiar with it. Hopefully you're not having to deal with too many of these claims. As you may be aware, the EU has a strict liability regime established under the Product Liability Directive, or PLD. And when I say strict liability, what I mean by that is that Europe set up a deliberately claimant-friendly statutory regime where claimants can recover damages caused by a defective product from the producer, whether or not the producer was at fault. The claimants can also bring claims in fault-based regimes like contract and tort, as they can in the US and other jurisdictions. But because they don't have to establish fault under the strict liability regime, they tend to prefer using that because it's an easier way to bring claims. And it's worth noting that the PLD is a sort of deliberately one-size-fits-all approach. So unlike the regulatory regimes that we talked about at the start of this webinar, which take a more sectoral or product-specific approach, on the product liability side, there's one directive, and the product liability directive can cover all manner of goods. So over the last 40 years, it's covered everything from vaccines to bicycles, metal hips, a piece of litigation I litigated for some time, nuclear reactors. The list is endless and very varied. And there've been sort of growing level of calls from various different stakeholders to revise the regime, notwithstanding the fact that it's been so flexible over the years. And the main driver for that was a belief that it was no longer fit for purpose in the context of new technologies. PLD is, as I say, nearly 4 decades old. It was drafted in the early 1980s in an era of VCRs and pagers, and we live in a very different world now, of course. A world of connected products, robotics, wearables, the metaverse, if that's still a thing, and increasingly artificial intelligence. And supply chains have also completely changed in that period. So when the PLD was drafted, e-commerce just didn't exist. And to put that in perspective, it wasn't until a decade after the PLD came into force that Jeff Bezos started selling books out of his garage. So this is a piece of legislation that was drafted in a different time, and the types of supply chain and the types of products that are on the market now were not foreseen by the drafters of the PLD. That's not to say that it was wildly unsuitable. And in fact, when the Commission carried out its consultation in 2018 to assess whether it remained fit for purpose, largely it found that it did, and that it had been very flexible and capable of adapting to the changes in the marketplace that we've seen over that period. Its final conclusion was that it struck a reasonable balance between different stakeholders, between different interests, and it was flexible enough on the whole to cope with technological change, but that it would benefit from some clarifications in light of developing technologies. And it's worth sort of bearing that conclusion in mind because that background gives the justification for why many practitioners like me expected this to be a pretty light touch reform, which is not what the Commission ended up doing. Once they opened the bonnet of the PLD, they did a lot more tinkering, I think, than anyone expected. So, sort of bearing that mandate in mind, what did we get? Well, this slide starts to look at some of the changes that we're going to get, and they started with the fundamentals. So they addressed what is a product, and previously that only covered hardware. It was tangible products, but under the new regime that will be expanded out to cover not just hardware products, but also all software, including standalone software, artificial intelligence, and also certain services. So quite a significant expansion from the prior regime. And the prior regime, as I said, was quite claimant friendly, and part of that was because it was prompted by the thalidomide scandal. So there was this belief that the sort of policymakers should take a particularly claimant sensitive approach and protect them where there were particular risks to their health and safety. And so it took this sort of unusual step of introducing a strict liability regime, alleviating claimants of the need to prove fault. I think in the context of software, you see risks that are very different and perhaps not at the same level as you might see with the types of risks that you get with medicinal products, which prompted this regime. They don't tend to create sort of risks to health and safety in the same way as tangible products can. So it's not being clear to me as a practitioner why the sort of European policymakers are taking such an extreme step as creating a strict liability regime around software risks, quite simply because you just don't see the same kind of physical risks coming out of your Angry Birds app or whatever other piece of software you have sold to you as a consumer. Second sort of big change is the broader concept of defects. So again, a fundamental change, defects sitting at the heart of the product liability regime. Previously, defects were very much focused on kind of fundamental issues with around safety of the product. The concept of what could be constituted within safety has been broadened significantly to include risks resulting from things like cybersecurity issues, software glitches, that kind of thing, connectivity risks, and also software updates or even lack of updates. So that's quite a significant step, particularly when it comes to the lack of software updates, because a product can be held defective not because there was some issue with the software that was on the product, but even if the manufacturer, the producer hadn't taken steps to issue a software update. So a lack of updates could render it defective as well. That to me is problematic as a practitioner that has a foot in both the regulatory and the liability side, because it's sort of regulating through the back door. We already have regulations that set minimum software update periods in Europe, and what this does is it lengthens those out, because the product liability directive creates at least a 10-year liability period under the long stop, meaning that there are sort of increased incentive to continue to release software updates over that whole 10-year period, to mitigate liability, even if you don't have a direct regulatory responsibility on the front end. So more available damages, third big change, covering data loss and certain types of psychological harm for the first time. So you can bring claims under the new regime parallel to GDPR, and also recover for things like mental harms. Some practitioners are proposing that you might even be able to cover things like anxiety if it's been diagnosed by a doctor. Then fourth sort of significant change, and this is where we start to really depart from the original mandate, is alleviation of the burden of proof. There was a feeling amongst policymakers that it was too difficult for claimants still to bring successful claims. And so there are a number of circumstances under the new regime where the burden of proof for claimants can be reversed, meaning that defect and/or causation can be assumed, and they no longer have to make that out. And in fact, the burden flips, so defendants will have to demonstrate that the product wasn't effective or didn't cause the damage. If I can go on to the next slide, just going to rattle through the last ones here. New disclosure obligations, another major change within the new regime. Discovery isn't something that's a tradition in Europe. In many jurisdictions in Europe, they rely on expert evidence and don't have a history of discovery or disclosure. The new PLD regime is going to bring forward a harmonized discovery regime in Europe. So that's a significant procedural change. There are new actors that come into scope of liability for the first time. Previously, producer liability was focused on manufacturers or importers largely, and under the new regime, a number of operators can be held liable, including fulfillment service providers and online marketplaces, albeit only in quite limited circumstances. Then there are some implications for software liabilities. There are open questions around that will need to be sort of resolved in sort of proceedings once they're brought under the new regime, about how those liabilities are sort of allocated within the supply chain, much more complex in the software context. And then finally, there's also some changes to the time limits. Previously, I talked about the 10-year long stop. There's provision to allow for extending out liability periods for certain products where harm takes longer to arise, that sort of latent damage type cases. So just a word on where we are now. As I say, the new directive will apply from December this year. Member states are just in the final stages of implementing national legislation required to bring those new rules into effect at member state level. So if I could just skip on a couple of slides, then I was just going to touch very briefly, a couple of minutes we have left, on the new representative actions directive. Or only to say really that alongside the reform of the product liability regime in Europe, in the last couple of years, we've also seen a new class actions regime come into effect in Europe. And taken together, that's a very significant change. And I think what we expect to see off the back of that reform of both the product liability regime and the introduction of a new class actions regime is a pretty significant uptick in products claims. Certainly, we've seen a huge influx of US plaintiff firms who have come into Europe and set up offices in London and across a number of European hubs to service that anticipated new market, and very big investments as well from a number of litigation funders and also a number of hedge funds. So some plaintiff firms have had investments to the tune of $500 million to pursue class actions in the product space in Europe over the next few years. So what do I sort of conclude off the back of all of that? Well, I think the sort of regulatory compliance piece is becoming increasingly important on the front end because the litigation risks are increasing. They're increasing quite quickly, and I think we're moving in Europe towards a world that is much closer to the US environment when it comes to sort of products risks on the back end. So I'm going to stop talking there, because I want to allow time for some questions. I can see some filtering through. Geraldine, do you want to be master of ceremonies for the questions?
Of course. So we've only got 4 minutes left, but I don't know about everybody else, but I was so engrossed in all of that. I'm definitely going to sleep well tonight. That was so much information. So we got such great value for investing our time. I hope that you all agree with me. There are a few questions that have come through. We will try and address those. And if we go on to the next slide, actually, we've got your details. So I just wanted to say thank you so much, because you give some real practical advice. And, you know, it was so much information that we had there. I'm definitely going to be watching back the recording myself. The recording will be available, as always, on the SPSP website, and also the slides are going to be available. And you have kindly put your details on there. So if it was me, I would be jumping at that and emailing all of you, because I think one thing that's screaming out to me is that I feel so lucky that I know you all, that I know the team at Cooley's, and I can just send an email and ask a question. And I think now more than ever, we need to build our network, because there is so much that we have to deal with, and we're here to support you. And that's why the SPSP are here to support you, Cooley are here to support you. So please do reach out with the specific questions that you had. I've seen a few of them and they are quite specific, so it's probably best that they're addressed actually directly. So please do email directly, as we mentioned, SPSP, or directly to the Cooley team. I also wanted to recommend, a recommendation I'm going to give is to make sure that you look up the Product Wise information. Cooley do a really great newsletter called Product Wise. So I would highly recommend searching that up and signing up to that. Also connecting with the team on LinkedIn. They do some amazing posts, and it just helps try and condense some of this really overwhelming information. So I was going to recommend that. I don't know if you want to recommend anything else before I do some final thoughts. Ed, Fergal, or Carol, anything to add before I have some final?
Just to reiterate, yeah, please do feel free to reach out. I know there's so much happening in Europe at the moment, and it can feel quite overwhelming. So we always find we have to sort of rattle through these updates. But if you sort of notice things there that you were particularly pertinent to your business, please feel free to reach out. We're so happy to help, and we love to hear from you. So yeah, just to reiterate that, thank you.
You've made me feel better on why I feel so overwhelmed with the amount of work we have to do. This is the reason why, because there's so much. So again, thank you so much to Sedgwick for helping us put on these webinars, and also to let you know that next week, something really exciting is that the SPSP certification program, the registration is open next week, April 22nd. So please do take a look at that. And that's where you can build your network and also find out more and educate yourself more on product safety. That's a really great course that's happening in the US. So I think on that note, I'm going to say thank you so much, Fergal, Ed and Carol. It's been an absolute pleasure. I'm excited to watch back the video because I need to digest all of that again, but it's been absolutely amazing spending the last hour with you. And also thank you everyone else for attending this session.